Hello and welcome. We're delighted to have you here with us this evening. Welcome to Keeping the Light On, Holding Government Accountable. I'm Laura Simoes, the Executive Director of the Nackey S. Loeb School of Communications. For those of you who are new to our school, we are a 22-year-old nonprofit. We were established with a mission to promote and defend the First Amendment of the U.S. Constitution and to foster interest, integrity, and excellence in journalism and in all forms of communication. And we do this by educating students of various ages and providing them with the tools and knowledge to improve their communication skills and to help them understand more about the 5 freedoms contained in the First Amendment. You are all a part of this mission just by being with us this evening, by attending events and classes, and you can learn more about our work at our website. That's loebschool.org. In a moment, I'm going to hand things over to our moderator, but first I want to thank our co-host for this webinar, the New England First Amendment Coalition. NEFAC has great programs this week and all year round. You can learn more at their website, NEFAC.org, NEFAC.org. The New England First Amendment Coalition is continuing an introductory series on public record laws with new classes on the appeal process for individual states in New England and the Federal Freedom of Information Act, introductory content on public records law, and a collection of 3 stories about public record cases in New Hampshire are online modules. You can access these at any time. These are hosted by Emily Sweeney of the Boston Globe, and they can be viewed online at nefac.org. This Wednesday, in just a couple days at 6 p.m., Attorney Greg Sullivan, who's also with us this evening, will join a webinar to explain how to appeal public records request denials. And he will provide tips on how to obtain records when an agency claims they may be exempt from disclosure. This online session is called Public Record Appeals. Learn how to fight back when your records request is denied. The session is free, it's open to the public, and registration is at nefac.org. So let's settle in for this evening's webinar. If you would like to ask a question during the evening, you can use the Q&A button at the bottom of your screen. We will all be watching throughout the session for your questions. We are recording this webinar, and we will post that recording to our Loeb School website this week. This evening's panel, Keeping the Light On, Holding Government Accountable, is moderated by Casey McDermott. Casey is a reporter and editor at New Hampshire Public Radio. Our panelists are GILLES BISSONNETTE, the legal director for the ACLU, New Hampshire, the Honorable William DELKER, Justice for the New Hampshire Superior Court, Emily Gray Rice, City Solicitor for the City of Manchester, New Hampshire, and Gregory V. Sullivan from Malloy and Sullivan, a First Amendment law specialist and a board member of both the Loeb School and NEFAC. I want to say welcome to all of you and thank you so much for your time and your expertise this evening.
Thank you so much, Laura, for hosting us. And thanks again to my fellow panelists tonight. There's a wealth of knowledge on display, and I'm really eager to dive into the conversation. Just to echo what Laura was saying, I would welcome any of the attendees tonight. At any point, please send us questions. We really want this to be interactive. We want this to feel like you're in conversation with each of these individuals who are here, who've been generous enough to share their time and their expertise tonight. So with that, I would love to start off, given that the theme of tonight's conversation is keeping the light on, holding government accountable. I'd really like to hear from each of our panelists tonight to get a better sense of, in your respective arenas, Is the light, in other words, kind of the spotlight on public access and accountability, is that light shining more brightly or less brightly compared to this time last year? And I am going to start off with Justice DELKER. I would love to give the floor over to you to hear your response first.
Sure. So I guess my short answer to that is I think the light is shining as brightly as it always has. New Hampshire is, we always like to think of ourselves as exceptional, but we, in some respects, are really an exceptional state. And in one of those ways, we are one of a very small handful of states that have in our founding document the principle that government officials are accountable to the voters and to the citizens of the state. And excuse me, in Part 1, Article 8 of the New Hampshire Constitution, which was part of the original Declaration of Rights back, Bill of Rights of the New Hampshire Constitution back in 1784, when our existing Constitution was first put in place. That's existed since then and was amended one time in 1976 to make it explicit that the public has a right of access to all government proceedings and records, and that that access cannot be unreasonably restricted. So this, we talk a lot about the right to know law, which is a statute, but I think it's important to keep in mind that this is really a foundational principle of our government here in New Hampshire, and has been since the beginning of our republic.
I will turn the floor over now to Gilles. I'd love to hear your thoughts on that as well.
Sure, and I can't echo Justice DELKER enough. The fact that government transparency is not just something that's memorialized in our right to know law, but it's enshrined in the Constitution, and I really think reflects a really important value in the state that is indeed unique. But sometimes there is a difference between how things are implemented actually in practice. And until a couple of years ago, we did go through a 30-year stretch in New Hampshire where we really could not get access to government employee personnel information, particularly with respect to government employees like law enforcement that have immense power over the citizenry, can use lethal force, have the ability to deprive individuals of their liberty. And so as important as those constitutional protections are, I think we're in a little bit of a rough patch for a few decades. That did change. So to get to your question kind of more directly, Casey, are things more kind of in the sunshine now than they were previously? I think the answer is yes. And it is in part due to two court decisions that came down in late May of 2020 out of Portsmouth and the town of Salem. I'm not going to get into the details of it, but what the Supreme Court did was really something unique and amazing, and they really should be credited for it. They reversed a decision from the early 90s that basically said, even if there's a strong public interest in disclosure with respect to government employee personnel information, it's just categorically secret, period, full stop. And the court revisited that in May 2020 and essentially said, we got it wrong. We got the statutory analysis wrong. And in fact, there should be a public interest balancing analysis with respect to that information. And what does that really mean? It doesn't mean that in all instances that information will become public. It just means that it's very fact dependent. It will depend on the particular circumstances of that case. But I can't tell you just really how important that was. And, I also think putting it in context is important. That those decisions came down 4 days after George Floyd was murdered in Minnesota, where protests swept the country, including here in New Hampshire, where people were expressing serious concern with respect to police accountability and how we as a citizenry can make sure that we know what the police are up to. I mean, when you look at the Minnesota example, Minnesota at the time was actually even more transparent than New Hampshire. We knew that one of the officers involved had multiple incidents of alleged misconduct. And here in New Hampshire, you couldn't get access to that until May of 2020. Since May of 2020, I think we've seen some very positive steps. As a result of this new public interest balancing test, a lot of municipalities have gone through the process of reevaluating their practices and have disclosed information without litigation and have said, you know, listen, yeah, these documents are important. They belong to the public. We think the privacy interests here are minimal because we're dealing with an officer who may have engaged in misconduct in their official duties. And the public interest is high as a result. So they'll give it over. Some haven't. And that has resulted in subsequent litigation. There have been multiple cases in the Superior Court, largely been successful, where courts have ordered municipalities under this due balancing test to produce this information. There has not yet been a New Hampshire Supreme Court case going through this balancing test. We've just seen it at the Superior Court level, but I can tell you that there is a decision that we're all waiting on, including my office, including municipal lawyers, called the Provenza case. That will, I think, really should set the tone and should set the standard, hopefully going forward, so we can all have a little bit of greater clarity as to how this test would be employed in practice. One last thing I want to say, Casey, before I turn it over to others. I know I've been talking a while. There's been, I think, a little bit of a hiccup over the last couple months where I am now seeing municipalities, well, honestly, municipalities, police unions, arguing that as a result of a decision that came down a couple of weeks ago dealing specifically with how police records are managed in criminal cases. And there, the Supreme Court held that in the context of a criminal case, when a defendant gets police personnel information, that defense lawyer needs to keep it confidential. I am now starting to see an argument from police unions that that decision actually means that in the right to know law context, police records are categorically secret. I am very concerned about that argument. I don't think it's right. Provenza may address some of that, the Supreme Court case that's coming down, but that would undo the last 30 years of, it would undo the victories that we've secured over the last 2 years and bring us back, if that's correct, to the 30 years of secrecy that we had, except in this instance, that secrecy would be unique to law enforcement. Only law enforcement would get the special protections of secrecy. We don't think that can be right. The police work for us. You know, they're paid by taxpayer dollars and have really a unique power to deprive individuals of their liberty. So that's kind of that's what I've been thinking about in particular over the last few weeks.
I'd love to come back to a few things that you mentioned, as well as some things that Justice DELKER mentioned, but let's hear from our other panelists, and then there's plenty of time to dive back into that. Attorney Sullivan, I would love to hear your thoughts on that same question. Are we seeing more light or less light than this time last year in New Hampshire?
As Attorney Bissonnette just said, he mentioned two decisions in May of 2020, Seacoast Newspapers versus the City of Portsmouth and Union Leader Corporation, and New Hampshire ACLU versus the town of Salem. But there was a third case argued that day, and Gilles and I argued two of them, I think it was. And that was Professor Salcetti against the City of Keene. And that case as well was a victory for the public's right to know what the government is up to. And it related to police misconduct, as the Portsmouth and Salem cases did, but it also involved other governmental departments within the City of Keene that had really, that case started out as an assignment from her class, political science class. And by the time we argued the case at the Supreme Court, all those kids who had made the public records request had graduated, but they came to the Supreme Court to listen to the argument. And so those three cases in May of 2020 really flipped the switch. And as Gilles mentioned, I think we were riding the winds of change that were sweeping across the nation as a result of the George Floyd and other police violence actions. So yeah, I think we made great gains. There are still issues, as Attorney Bissonnette just mentioned. Hard for me to say that instead of Gilles. But yeah, there are. I think we're going to get into some other issues that may be surfacing vis-a-vis the police unions, et cetera. But I go back to the 70s handling these cases, and from then to now, it's night to day. The Supreme Court in the late 90s issued some decisions that were beneficial to the public's right to know what the government is up to. But as Gilles mentioned, it was 27 years since the Supreme Court had issued this Fenneman decision, which said all records relating to internal investigations of police misconduct are categorically exempt. That is now out the window, and the same balancing test that's applied for all governmental records that are denied. We balance the public's interest in the disclosure versus any privacy or other governmental interest that is on the other side of the scales. And presumably because of our Constitution, because of our right to know law, and because, you know, this is our government, we the people are owning and running it, we'll continue to move in the right direction.
And Attorney Rice, how about where you sit? I know that you're maybe a different perspective than some of the other panelists that we have, and that you are on the receiving end of a lot of those requests for information, but I'm curious to hear your perspective on that as well.
Of course, thank you very much. In my current job, I head the legal department for the city of Manchester. So I see many right to know law requests. Earlier in my career, I worked for the Attorney General's office, and I also for 20 years represented WMUR TV. So I've really had a lot of experience on both sides of the issue. I think your question was sort of framed in terms of, you know, what has changed vis-a-vis the amount of sunlight shining on government over the last year or so. I think it's very interesting that there's been a significant amount of right to know law jurisprudence engaged in by litigants and by our Supreme Court during the same time that we've been living through a pandemic. And I think in addition to the law metamorphosing, as both Gilles and Greg suggested, I think the public changes all the time too, right? The public is not static. The public's interests, bandwidth, questions change, all the time. And I think we've seen during the pandemic really intense interest in, for example, the power of the government to regulate behavior based on public health interests. We've also, I think as was already mentioned, seen an intense amount of interest in the activities of law enforcement. We've also seen an intense level of interest in elections. So I think that as the law is changing, the emphasis of the various right to know law requests and public interests are also changing. So it's a very dynamic time to be in government, answering these requests. And I think it's also, our Supreme Court over the last several years has decided a pretty high volume of right to know law requests. We've talked about some of the more noteworthy decisions, but there was a decision that was issued late last fall involving the select board in the town of Ashland. We had the case against the city of Concord regarding the $5,000 or so expenditure. We had the petition of the state of New Hampshire, which involved discovery in a criminal case and kind of was looking for the nexus between the rules of criminal procedure, discovery, and the right to know law. So it's been a very dynamic area. I guess the biggest change that I've seen over the last 12 months is the number of requests coming out of academia. Because just as citizens are very interested, for example, in the activities of law enforcement, there's an effort being made by all sorts of academic institutions and PhD candidates in obtaining information, statistical information, primarily about the activities of law enforcement. So this is also a very highly studied area, in addition to an area of public interest. So I would say that those are the biggest changes that I've observed in the last 12 to 24 months.
If we could just stick with you for just a second, I'm curious, are you seeing any change in terms of the where the requests are coming from, not just in terms of the sphere? You had mentioned the growing number of requests coming from academia, but are you seeing changes in terms of like people who are local to Manchester versus people who are in other parts of the state versus people who are even outside of New Hampshire? And if so, do you have a sense of what people who are maybe, farther away are interested in that may be different than kind of your average Manchester resident?
Sure. I first of all, I would not agree that there is an average Manchester resident. So
as a Manchester resident,
that's the first thing. I would say that the people of Manchester are now and have always been intensely interested in what government is doing, how their tax dollars are being used, what city officials are doing, what can be done to make a great city better. I would say that the volume of out-of-state requests tends to sort of rise and fall at various points. So obviously, in an environment of a presidential election, there's a lot of intense interest from everywhere about Manchester information, because not only do we have the first in the nation primary, but we're the largest city in the state. Again, now I'm seeing most of the out-of-state requests having to do with studying law enforcement activities. In terms of the questions that come from inside the state of New Hampshire, my friends in the media keep us very, very busy all throughout the year. And also, around budget time, citizens are very interested. And then, people have all kinds of requests. I think that the greatest tension at this point, just kind of, sort of on the ground, is that, people are used to collecting information and collecting data sets in a very systemic way. And many times municipal technology and municipal archiving and record keeping practices are much more analog than the rest of the world. And so sometimes there's a clash there, because it can take a very, very long time for us to pour through a large data set, because it doesn't really exist as a data set. But we try to explain to people what we're doing, why it's taking so long, get them to prioritize their requests. But in terms of in-state and out-of-state, I would say that the largest requests for the largest data sets come from out-of-state.
And just one more, just while we're sticking on that theme, I'm also speaking as someone who I think sent at least 1 or 2 large volume data requests to your city in the last year, and appreciated the responses that I got back. But how do you, with that in mind, when you are, helping a city with so many different departments, with so many different kind of areas of responsibility that the city deals with, how do you try to coach your colleagues in different arenas to respond to those requests and get at, what are people actually looking for?
Sure. I think the best thing to do is to provide training. So we make training available to our employees and our elected officials about the right to know law, about both documents and about public meetings. Because obviously we're really focusing on the document side of things tonight, but a lot of what we do in government is try to follow the right to know law as it pertains to meetings as well. And then basically encourage dialogue. In other words, to encourage an interactive process between the requester and the appropriate department. Sometimes, in fact, oftentimes, the request comes in and it encompasses more than one department. But I think the key feature is basically to let people know about both the statutory and constitutional basis of our obligation as elected officials to and our commitment to transparency in government. This is not to say that we always agree, that we always agree with the requester. Sometimes we do get into litigation with media outlets about the extent of our obligation. But I think providing training is the key, providing resources from the New Hampshire Municipal Association and others. And again, just encouraging a discussion. I think that's really the most important thing, because I think communication, particularly during the time period when we were not all in our offices, when the public didn't have a lot of bandwidth to follow up and engage in these discussions, I just think it's really, really important to remember that at the end of the day, we work for the public. and that whether we agree or disagree with everything in the request, I think it's just important to have a dialogue and also to respond quickly and basically to explain if we can't give over the entire data set in 5 days, we need to have a plan for the way that we come up with that. So again, I think it's just a human interaction process really for the most part, but I think education and training up front is very, very important.
I want to go back to Justice DELKER for a moment, and I'm curious, maybe, albeit a different perspective, but as someone who is kind of watching different kinds of cases come across your bench, different kinds of requests, are you noticing any trends in terms of like the disclosure of information in court cases that have, that has struck you as kind of interesting or something that's worth noting?
Sure. One of the interesting sort of developments that I've seen lately is a tension between, so let me back up and say, based on Part 1, Article 8, and historically, all court records are presumptively open to the public unless there's a good reason to seal a court record. And so there's quite a bit of case law that's built up around that. The courts are not, do not fall under 91A, which is the right to know law. So our framework for analyzing these issues is the constitutional principle, as well as the common law, what we call the case law, that has developed around these principles. And so for most purposes, court proceedings are open. People can come and watch anything that happens in court. You can come in and look at court files and what gets filed in court. And the reason for that is because you want to know that your courts are operating appropriately and courts are making decisions based on appropriate factors and all of that. So one of the interesting trends that I've seen developing is tension between the state, the prosecution's desire to protect victims of violence, particularly sexual and domestic violence, and this public right of access to court proceedings. And so one thing that has happened over time without any law, without a rule, without sort of a case that says it, is all of the participants, the prosecutors, defense lawyers, the police, the courts, have begun to refer to alleged victims of violence by their initials instead of identifying them by name. That helps protect, give some level of anonymity to the people involved without shielding what's happening in the case and how the court is deciding the case. So at some level, that's a thing that's happened organically without any sort of legal decision coming out of it. On the other hand, I've noticed a concerted trend to put more pleadings under seal because the prosecution is arguing that exposing certain aspects of the case will be detrimental to the named victim in the case. And that stands then in tension with this public right of public access. And it's not an easy, the answer to that is not an easy answer. And it's really got to be decided on a case-by-case basis because certainly the idea of public access to court proceedings is core to our accountable government. And on the other hand, being a victim of a crime and having to participate in a public way is, that's difficult. I don't, being a witness, even if you're not the victim in a court case, is not an easy thing to do. And so recognizing that tension and that dynamic is that balance is hard, and something that I've seen developing sort of slowly over time.
We have kind of a practical question from one of our audience members, and then I'll let you jump in. Thanks. So Carla asks, how does one know that a case is sealed?
Well, so by and large, with very narrow exceptions, an entire case is not normally sealed. So, and when I say narrow exceptions, one example of that would be the parental notification. So under New Hampshire law, in order for a minor to have an abortion without notifying the parents, they've got to come to court and get permission to do that. And so those cases are sealed entirely. But that's sort of a truly an exception. It's more individual filings, like motions and pleadings in cases get filed under seal. So you know the case exists, but a lot of what's going on in the case, if those motions are filed under seal, then people don't really have a good sense of what's happening in the case and how it's progressing and in what direction it's progressing. And so you will see in the court, so from a public perspective, what you see in the court file is an entry in the docket of that case. And under the court rule, the entry has to identify in general what the motion is about. So let's say it's a motion to suppress certain evidence in the case, and the state wants that motion to suppress kept from the public. It has to at least say state's motion to suppress, so that you know that much is pending. And then there's a notation that that document is under seal. Actually, Greg and I sat on a subcommittee of the Supreme Court that developed rules around this and tried to control how much information was under seal, and to encourage or to require litigants to file as much in the public record as possible by filing two versions of a pleading, one under seal so the court could see, the judge could see all of what's written, and another that is what we call a redacted version that keeps sort of the non-confidential information in the public record, but keeps the confidential information. Maybe there's mental health issues, maybe there's very sensitive personal health or other issues going on in the case that really don't belong in the public domain, but also don't impede the public's understanding of what's happening in the case.
And actually,
can I chime in on that, Casey?
Yeah, go ahead.
Yeah. Oh, I didn't mean to interrupt you. I mean, one of the things just kind of in my practice that I am seeing just a little bit of are pleadings kind of sometimes being reflexively sealed. You know, it's where there's not a dispute between the parties that the document should be sealed. Where that could sometimes cause concern is that, yeah, the parties may want things to be secret, but there's this whole separate interest involved, right? Which is the ability of the public to be able to monitor, the action, to evaluate the parties, the case, and of course to evaluate the judiciary. And when kind of courts, and I'm not suggesting Judge DELKER does this. I've seen it elsewhere where kind of pleadings are reflectively sealed, and then it becomes incumbent upon a member of the public, number one, to learn about the pleading, and then number two, to go in and unseal it. And even though the burden should not be on the person trying to unseal it, kind of in practice becomes that way. And so, I mean, that's kind of something that I know that our organization is kind of working on to try to, have that happen a little bit less. I think it's not consistent with the rules, which I think clearly, again, the presumption is in favor of public access. My last point on that is, this is actually coming up recently with respect to the EES list. So there was a mechanism put in place where names on the list would become public unless someone decides to go to court and challenge their placement on the list. One of the things the courts kind of globally have sealed the entire case. And we don't think that's appropriate at all. I think it could be done in a far more tailored way, obviously, where you redact the name, but to kind of seal everything and have those cases dealing with police and whether they should be on that list or not, and have that done in secret with no government accountability, to say something that we're concerned about. We don't think it's consistent with the rules, and it's something that we're actively litigating.
So just to follow up on Attorney Bissonnette's point, I agree with him. I do think the lawyers tend to file motions under seal sort of reflexively and not file the redacted version because it's easier for them, to do it and just agree that the document's under seal. If it's, I've seen it in something as mundane as a motion to continue because the defendant tested positive for COVID, right? And I mean, well, yes, that's a health issue. I mean, how much of a privacy issue is that in today's day and age that somebody tested positive for COVID? And so, but you know, somebody made an objection. Could that motion to continue have been filed publicly with a redaction about the defendant's health condition? Let's say it was something more sensitive about the reason the defendant or let's say the victim was asked, you know, had some issue in the case, health issue that was more sensitive. You know, you should be, and the litigants should be filing a motion to continue that the public can see with that portion about the health concerns redacted from the pleading. And that's not happening. And I think that doesn't happen mostly because it's a lot of work on the lawyers and they're all pressed for time. And it's just easier to agree to put it under seal. Well,
if I may jump in, Casey, I mean, that was sort of the issue in the petition of the state of New Hampshire, right? The parties, the state was going to produce some personnel information under 105.13b. All the parties agreed that the information could be protected under a protective order, and the judge said no. His initial read was that to allow that to happen would be to keep from the public information that they would otherwise be entitled to. As Gilles pointed out earlier, the court actually agreed. The court actually disagreed with the lower court, but it was that was the way that the issue was framed. Is that the judge declined to exercise that power based on the right to know law. And I guess it sounds like there are a number of different interpretations of that opinion, but that's where it went.
I know Attorney Sullivan has been trying to jump in. I want to give you a chance to respond.
Oh no, if I was trying, I would have. But at this point, I want to say, particularly to Gilles, if a police officer is going to court to take his name potentially off the lorry list or the EES schedule, why shouldn't that be public information? Perhaps when the name is released, 23 people are going to show up and say, yeah, he lied in my case, or he used excessive force on me. I don't believe those proceedings should be secret. Just my 2 cents.
We're about to litigate that, so.
All right.
Where might one look if they're interested in following that case?
So I could just tell you that part of the Attorney General's reporting requirements as part of the law that was passed last year is to identify by case number the lawsuits that have been filed. And that was deliberate, you know, so members of the public can then, you know, if they had access to the Odyssey system, could kind of then go in and see the pleadings. But the way the court system is managed, this actually is, if you type, I think until recently, I think if you typed in their number, you wouldn't see anything, right? Because all the cases are under seal. So that's just, I think, another reason why we thought kind of doing some advocacy around these cases would be critically important. Even if the names, you know, are redacted, we think it's still important for the public to be able to evaluate, you know, what was the reason the officer was placed on the list, so the public can evaluate how the court manages that particular process, so there can be public accountability as to the court decisions that are issued. So that would be my recommendation. I'm always happy to talk to anyone about our work in that area.
And just
I can't comment specifically on this topic because it may be an issue of litigation, obviously, that I might have to deal with. But in general terms, you know, this idea that a case might be partially obscured from, but not completely, happens with a lot of frequency. I mean, even let me just sort of give you an example in the civil context. You know, we will see very frequently a civil lawsuit filed in which a plaintiff brings the case as a John Doe or Jane Doe, so that they're using a pseudonym and alleging, you know, that they were, say, a victim of sexual assault, and they're suing the perpetrator of that sexual assault, but they don't want sort of to identify themselves publicly as the victim in that context. And there you can do it. I mean, at least in that context, it happens quite frequently that you can provide partial obscurity, and, you know, also using initials, like I said before, is another way that courts have dealt with this issue in part. Now, again, I can't comment specifically on the right to know law, but this notion is something courts grapple with all the time.
I just had two quick follow-up questions, just for the sake of, these may seem very simple, but just to make sure that the members of the public that are listening in are clear on what avenues are available to them to better understand some of these mechanisms that we're talking about. So going back to Attorney Bissonnette, you were talking about the EES list or the Lori list. So if I'm a member of the public who, sees that record, I should be able to go to that record, and on there will be a case number that will theoretically correspond with a case related to that particular officer that's on the list. Am I understanding you correctly there?
Yeah, there's two different things. There's the actual list the public list that's been released concerning officers who haven't challenged their placement. And then there's a separate reporting document that the Attorney General has created that identifies the case numbers of those officers who have gone to court. So you can kind of match up. You have the cases plus those who haven't challenged it who are on the list. So that's the process.
And then I think I'll turn this over to either Justice DELKER or Attorney Sullivan. But with regard to, so say I'm someone who finds out I'm following a particular court case and there's a filing that's under seal. Can I, as a member of the public or just anyone, petition to unseal that information, or do I have to be a party in that original case?
Go ahead, Justice DELKER.
No, you know firsthand, so you can answer.
Yeah, any member, any citizen, any member of the public can file what's called a motion to intervene and unseal records. That's generally what I call the pleadings that I file in an instance like that on behalf of one of my clients.
And on that note, if we'll just stick with the two of you for a moment, I know each of you were involved in a recent case involving a request to unseal records related to court sanctions that had been imposed on the Hillsborough County Attorney's Office. Justice DELKER, I know that you're not able to comment on that specific case because there's still some things in motion there. But Attorney Sullivan, you were involved on behalf of the Union Leader Corporation and the New England First Amendment Coalition, asking the court to unseal some records. Why was it important in your view to have those particular records unsealed?
I was looking at the memorandum that we filed in that case, and the last sentence struck me. I guess I drafted it, but it says, "Nowhere within the field of governmental accountability is the light of public scrutiny more critical than when it shines within our courts of law." And I say that because of the so important role that the courts play in regulating society. And in cases, without being too specific, in cases where a court is saying to a party, you're not complying with deadlines or with court orders, and the responding party does so with a petition to seal their filings, to me, that's we've got two branches of government or two departments of the justice system involved, the court system, and in that case, that theoretical case, the prosecution, the county attorney's office. So again, the roles are so important to the public that to me, it's obvious that the public needs to be able to evaluate the performance of all governmental actors involved.
Justice DELKER, feel free to.
As you recognized, I can't comment on that case specifically, but I wanted to go back to your original question, which was, what's the process for someone who wants access to something that's sealed? And I have to say, you don't need a lawyer to do this. I see this happen quite frequently where mostly reporters, because they're the ones who sort of the non-lawyers who tend to be hanging around the courthouse. And if, let's say I'm having a hearing on something that a journalist reporter is interested in, and there's a motion to seal that hearing because there's going to be some sensitive information discussed during the hearing. I have very frequently had a reporter stand up and say, I object to that. I want to be heard on that motion to seal. I think this is an important issue. and, they're not typically not lawyers. They'll make their argument. They understand sort of the importance of public access. And in that moment, and that's the time you need to do it, because we're about to have a hearing that's going to be closed and they want to cover it, live or more or less in real time. And so you don't need to be a lawyer, is what I'm trying to say, to make these kind of motions.
And I would just add, Casey, that the standard is permissive. Anyone really has the legal right to intervene as a member of the public. So it's the courts will generally let anyone, make those motions and be heard.
And for the journalists listening, they also have the right to say, Your Honor, could you please postpone the hearing until such time as I can have my lawyer appear and argue on my behalf?
I can see how that would be critical in certain circumstances as well. Justice DELKER, I want to stick with you just for a moment, because a few of your fellow panelists touched on this idea of the court system also being a branch of government that should be subject to, that should be open, that should be accountable to the public. I wonder, speaking in general terms, how you think about your role and how you try to kind of keep your courtroom open and accountable to people who may be wanting to observe how you're functioning.
Yeah, there's no doubt about it. And the case law is very clear on that point, which is courts are presumptively open to the public, and anyone can come and watch anything we do. In fact, I do a lot of civics education with high school and sometimes middle school students, and I really encourage them to come and watch, and I love it when they come, and then we can have a discussion about the cases that just happened, because I think it's a really great opportunity for people to learn about what, not only their courts, but the prosecutors and the defense lawyers and what's happening in, one of the three branches of government. I think one of the biggest challenges that I've faced in my career on this issue is during the pandemic, balancing the public health risks of large groups of people in a confined space with the need to keep, because we continued to do jury trials in particular and other proceedings throughout the pandemic. And when we were doing things live in court, when we were doing things virtually, it was easy to make it open to the public because anyone could ask for a link and they could sign in and they could watch what happened in a hearing by what we use WebEx technology, but Zoom, same idea. What was much, much more challenging during the pandemic was when we were doing trials and we had to limit the number of people in the courtroom for public safety, but we also had to make sure that anyone who wanted to see that case happen could have access to it, and we could provide that. And so we came up with mechanisms to do that with closed circuit TV in another courtroom, and allowing some members of the public to be present, and sort of not manipulating, but sort of working within the structure we had to make it a safe environment, but to still keep it open.
I want to return to, we've talked a lot or touched on the issue of the Lori list in this conversation so far. I know that has been, really in the limelight, especially in the last year, as more portions of that list have been released to the public for the first time. I'll put this question, I think, first to Attorney Bissonnette, and then I would love to hear others' thoughts on this. But what kind of impact do you think that these new disclosures have had so far? And do you think this has led to any kind of greater move toward more transparency in law enforcement records in general?
I think the release of portions of that list, it's not yet complete, have been really significant. Just for those folks who have maybe heard about this list, but don't really know kind of what its function is or how it's used. The Lori list, or what's also called the exculpatory evidence schedule, is a list maintained by prosecutors as a flagging mechanism for when an officer who may be testifying in a criminal case may have an issue in their personnel file dealing with their credibility or trustworthiness that would need to be disclosed to the defendant in a criminal case. And so that's why the list kind of works, and it exists so prosecutors in essence don't have to go in every criminal case through every police officer's personnel file. And so it's that why it was created, really for efficiency purposes. But of course, with the creation of that list, I think also comes then a public interest in disclosure with respect to that list, because it not only helps evaluate how prosecutors are performing their prosecutorial responsibilities, which is, I think, a significant public interest. It also is reflective of police officers' potential misconduct. And so we, along with various media outlets, including Greg, filed a lawsuit on that back in 2018. And that culminated after kind of multiple periods of litigation, both the Superior Court and the Supreme Court, led to a statute that kind of implemented this rollout of the list that I conveyed before. And so that statute is starting to be implemented. And that's why back in December, we started to get a round, at least a first round of names. There'll be another round of names in March. The document is actually kind of a tight document. It has the name of the officer, the police department, the date of placement on the list, the date of incident. Those aren't always the same. It's actually material. Sometimes if you have an incident that happens 5 years before placement, that's 5 years where their disclosures may not have been made, and maybe they should have been made. And then you also have a column at the end of the document that just lists a couple words. So, it's not always easy to understand why an officer's on the list. It could be for something really minor. It could be for something really significant. Why the list is important is, and we've seen it in a series of news articles that have come out, including by NHPR. Some of those officers are still working, and to the extent that the misconduct is serious, maybe that's a problem. If the misconduct is not that serious, maybe that's okay. But part and parcel with disclosure of this list, I think, needs to also be disclosure of the underlying misconduct, so the public can then evaluate whether, this officer maybe is a bad officer, or maybe just isn't, and made really one small, mistake that still was a credibility mistake that requires placement. So to me, really, all of this needs to see the light of day. The list is just the EES is just a piece of it, right? But the underlying misconduct also needs to come out as well, to create a fuller picture of law enforcement that may have credibility issues. So what you are seeing now, it also in response to the court decisions from 2 years ago that made police personnel records at least more public under the balancing test, is now we're actually making requests for some of the personnel file informations of those officers that are on the list that have become public, to try to paint a more full picture and kind of solve this puzzle of some officers who may have issues. Not all officers have issues. I want to be very clear. Our position just at the ACLU is, if there's been misconduct, given the unique role of police, really the public needs to have access to that information.
Attorney Sullivan, I would love to hear your thoughts on that as well, given your involvement in some of that litigation.
Yeah, the legislature took action, presumably based upon where that litigation was headed. An issue that to me is really important, and it's a little bit to the side of the EES, is the hearings before the New Hampshire Police Standards and Training Council. Every police officer in New Hampshire has to be certified annually. Until recently, the officer had the option to request that hearing be held in secret, and my clients objected to that and prevailed, at least in the Superior Court. But what remains there is the issue of when the charges that are brought are unsustained, and this spills over into not just law enforcement, to other governmental actors. When the charges are not sustained, some governmental actors are saying that information should be kept secret. And I have a little bit of trouble understanding that. Were someone charged with misconduct and an independent body determined that those charges were not warranted or not sustained, I'd want everybody to know that. And I think that's a point that Jill just made, and I always try to make it, is that 99% of the governmental actors we're talking about are doing their best to do a great job. It's that old adage of one bad apple spoils the bunch. And unfortunately, I think that's true. But what I like about transparency in these situations is that very often it shows that the officer involved or the governmental actor involved did a good job. There was no misconduct. So, you know, it's not just show the bad conduct. To me, it's show the good conduct when appropriate. And that's what transparency is all about.
Casey, if I could chime in, I can't emphasize enough how critical and significant the union leaders' lawsuit was in reopening police standards and trainings hearings, because for the most part, any type of decertification action, the substance of it, not the end result, but just why the officer had a certification ramification, the underlying facts, all of that had been secret for years. And so that is very significant development. Those hearings happen once a month. They've been open now, for the most part, for the past 9 months under that court decision. And we've seen things that we never would have had access to as a result. You know, an officer, a state trooper recently got decertified as a result for having a sexual relationship with a witness. I don't think we would have gotten those details if that hearing was secret. And, you know, a Dover police officer was decertified recently about lying about a high-speed chase. So I think just a real huge win for public access there.
I want to go back, Attorney Sullivan, just for a moment about the Police Standards Training Council and their role. I mean, correct me if I'm wrong, it's somewhat of a quasi-judicial kind of process. And in the same way that we were describing the function of the right to know law, open access to government proceedings as being a way to monitor not just kind of the parties in those cases, but also the institution that is adjudicating those cases. Do you see this as a win for holding that body accountable as well?
100%. The officer involved, the supervising officers at that department, and those members of the Police Standards and Training Council that take part in the hearings. They're all governmental actors, and we have the right to watch and know what's going on.
We have another question from the audience that I'd love to get to at this point. And I will let anyone raise their hand who's interested in taking a stab at this. This comes from Jonathan Van Fleet, my former editor at the Concord Monitor. Thank you for tuning in. Government accountability to the people is enshrined in the state constitution, yet the governor's office, first under Maggie Hassan and now under Chris Sununu, argues it is exempt by asserting executive privilege. What good is Article 1, Part 8 if it can be so easily cast aside? Attorney Sullivan, would you like to take a stab at that?
Sure. Yeah, by statute, the governor is only subject to the right to know law when meeting with the governor's council, which is kind of an anomaly. Do I think Part 1, Article 8 of the Constitution renders the governor transparent and accountable to the people? I certainly do. So they can claim executive privilege, but in an appropriate case, that can certainly be challenged. The materials can be submitted to a court, redacted, under seal, and a court can determine whether or not the public interest outweighs whatever the governmental interest is in secrecy. But just as the courts are not subject to 91A, and if the governor believes he or she is not accountable under 91A, so it's Part 1, Article 8 of the New Hampshire, and Part 1, Article 22, both, that's freedom of the press, which is essential to the security of freedom in New Hampshire. I believe all governmental actors need to be accountable to the people at all times, absent, specific needed exemptions.
Hey, Casey, there is a New Hampshire Supreme Court case that's pending on the scope of the governor's executive privilege authority. So I think I'm awaiting the outcome of that, I think, as a lot of us are.
Just for the sake of clarifying for our audience here, could you elaborate on the nature of that particular case?
Sure. There was, this is actually somewhat germane to what's going on right now here in Concord. A couple of years ago, there was an effort in the legislature to pass a bill that would try to reduce partisan gerrymandering and to do so through kind of a redistricting commission. That bill was ultimately vetoed by the governor. A public records request under not 91A, but Part 1, Article 8, was made to the governor. I hope I have my facts right. Was made to the governor to try to learn about, why that decision was made. Were there communications with outside entities, political actors between those entities and the governor's office? So there was a request made for some of that information. A claim of privilege was raised. Now that issue, the scope of the privilege and whether those documents are exempt under the privilege is now before the state Supreme Court. And if I'm wrong on any of that, I hope folks can correct me on the call.
So Casey, the only other thing I want to say on the subject generally, because I can't comment specifically on when and under what circumstances the executive privilege may apply, because that again may be an issue that is in litigation and may continue to be in litigation. But I think what's important to keep in mind is what Part 1, Article 8 says is that the public's right of and I'm quoting here, the public's right of access to governmental proceedings and records shall not be, and here's the key words, I think, unreasonably restricted. And so, that is where the rubber hits the road in terms of what litigation in cases are, is what's an unreasonable restriction. And there are all kinds of privileges that exist. There's attorney-client privilege, there's work product privilege that are well recognized in the law, that the right to know law, the statute automatically exempts those kind of things from public access, and so that government can operate in a way that has been recognized historically. And so, this is sort of where much of our work as courts come into play, these kind of words like unreasonable. We see it all the time in the search and seizure context. The Constitution doesn't, protects only unreasonable, protects people against unreasonable searches and seizures. And so, a lot of law builds up around over time about what is unreasonable, what does the law recognize as reasonable versus unreasonable. And that's what these cases that Greg and Emily and Jill have been talking about really help us develop a body of law to understand those parameters.
Yeah, on that note, on the federal level, there was a fellow named Nixon who claimed executive privilege extensively, and the courts upheld some, and others ruled that the documents had to be disclosed. Every case turns on its own set of facts.
Attorney Rice, I think, do you have something that you wanted to add there?
No, I was just going to say that area of the law depends very, very much on the federal side on whether or not there's a national security interest. The theory behind executive privilege is that the executive, in order to do his or her job, needs to be able to consult with trusted advisors without sort of being under the microscope. Some people think that that is absolutely forbidden, because why would the executive need to interact with trusted advisors and receive secret advice? As we all know, we know what happened in the Nixon case, which is that his attempts were struck down. He was persuaded to resign so he wouldn't be impeached. And obviously the media was very famously involved in the key cases. But I think we'll all be interested to see what the Supreme Court decides in this pending case, which I think has been pending for a while.
And there seems to be some executive privilege cases brewing on the federal level as well these days.
Just a few.
I just want to put a plug in as I'm looking at the time here. We would invite any other questions from people in the audience tonight. Please don't be shy. We'll do our best to fit them in with the limited time that we have left here this evening. Just going back to Attorney Rice, if I could just stick with you for a second, what do you think might be helpful for members of the public to understand about, how to craft an effective request for public information? Like, what's the best way to, if I'm just an average resident, to kind of make sure that I'm most likely to get what I'm looking for?
So, I mean, first of all, I want to emphasize that the public doesn't have an obligation to do that. In other words, as public officials, we have a responsibility to try and understand what is being requested. But obviously, it helps if you want a quick answer. It helps to be specific. You can also call people in government and ask them questions about how they keep certain records, or what records they keep, or where they might be stored. Here in Manchester, we have the advantage of having a city archivist who actually knows that information and is very, very well acquainted with sort of our historical records, and generally, as there's a record keeping statute that requires that municipalities retain certain records for certain amounts of time. So I think familiarizing yourself with what municipal and other governments keep on hand, I mean, that applies to the state government as well. And then I think to maybe give some sense of priority. In other words, I'm writing to request, all of the records concerning X, to put a time period on it, to say what you're most interested in, and what you would like to receive first. I mean, I think that's always helpful. And then I think too, to try to respond to any questions that you may get back either by email or by phone, because again, the clearer we can be and the better the lines of communication are, the more likely it is that we'll be able to respond quickly to the request. There is no requirement that citizens be specific. However, if you send in a very, very broad request without time limitations, that's going to require, the involvement of our information systems department. They're going to be, bulk email searches, which are going to turn up 10 or 20,000 emails. And at the end of the day, an individual, a human, has to look at that information in order to respond to your request. Very, very likely a human who has a job, administering a program or supervising people or providing a public service. That's just a human problem, right? A human factors problem. So I would just say, keeping the lines of communication open and, talking to the person about what it is you've requested and having a time period and some specificity is always helpful, but it's not required.
Attorney Sullivan, did you want to add anything to that?
If I could, yeah, everything Emily just said is 100% correct. But I remember the days in doing this work before this internet and email stuff came along, and reporters and individuals would tell me they made a request, they submitted it. Well, first of all, they say they submitted it orally. No, you got to put it in writing and you got to be specific. And then I'd say, did you keep a copy? No. So you put it in writing and make sure you keep a copy. But now we have this email system, which really takes care of both of those items, in writing and having a copy or a receipt. And I'll say the kids and the students in the Salcetti versus Keene case, most of the evidence that we presented to the court that was very persuasive were emails going back and forth. They could prove the city was saying, well, you've asked for lists. And of course, the city doesn't have to produce information that they don't keep in the format requested. So the students would request all records relating to excessive use of force in the police department. And the city would write back, we don't keep a list of that nature, so your request is denied. Well, ultimately, the Supreme Court held, after the Superior Court didn't, the Supreme Court held, no, they weren't asking for lists, they were asking for records. But it was the chain of emails that really won the day.
I'm curious, we have a question that I'd really like for us to get to, if that's okay. This comes from a member of the audience, Laura, would like us to talk a little bit about the right to know ombudsman bill that's up at the New Hampshire State House this year. I know we spent a lot of time tonight talking about what's going on in our court system, in City Hall, in other sectors of our government, but I think this is a very pertinent question. Laura writes, several towns in New Hampshire are fighting their residents and do not want to be held accountable and giving denials out for most of the information that residents are asking for. Laura says, I live in the city of Nashua and their legal department has told residents that if you do not like it, take us to court. At the same time, Laura says, I have gotten information from the city of Manchester with no problems, and then asked for the same information from the city of Nashua and have been denied. I can say as a reporter, that rings true in some respects, very different responses from different agencies on functionally the same information. I know the Concord Monitor did a really great piece recently looking at requests for information from, I think, every town in the state, and the differences in the types of responses that they received were quite illuminating. But to Laura's point, she says the problem is that there is no party or no one that residents can go to in order to get the information. And most residents do not have the money to keep taking their city to court. If there is a right to know law to be able to hold towns accountable, why is there no enforcement of this law without going to court? I know, Justice DELKER, you had mentioned earlier that, anyone can come to court and petition, for access to information. I'm curious, before we get into this bill, what avenues are available to someone who's just a regular citizen who thinks that their city or town is maybe not releasing the information that they think they should be releasing?
Sure. I mean, I recognize that it takes time to come to court for sure, but that again is not complicated. We have a process by which a self-represented litigant can fill out what we call a complaint, which sets forth what are they seeking, what's the issue that they want to bring to court, and then file that case. And then one of the important things to keep in mind is that the 91A, the right to know law, does actually have penalties for the town or the municipality if they unreasonably withhold information, if they should have disclosed it and have made a sort of intentional bad faith decision not to disclose information. And certainly something like paying back the cost of filing a lawsuit, or if there's a lawyer involved, those kind of things can be recouped if the litigant prevails in the long run and can show that the government was acting in bad faith. So, there is a remedy built into the statute for this kind of situation where, towns just can't dig their heels in because they do face potential serious consequences.
Attorney one moment, if we could just go to Attorney Sullivan, who I think has been waiting maybe to weigh in on this.
No, first of all, I agree with Justice DELKER, although to me, it's not just bad faith that the municipality or the town can be held accountable for. It's whether they knew or should have known that the information should be released, sort of a negligence standard, not just bad faith, although bad faith for sure should lead to an award of attorney's fees and costs. The ombudsman bill, I think, is a good idea. The practicalities of it down the road, if it passes, will certainly be tested. And one of the things that I think Gilles and I have talked about, which I'm not crazy about, is it says if you file with the ombudsman, you cannot file in the Superior Court. And if you filed in the Superior Court, you cannot file with the ombudsman. Now, to me, if I file with the ombudsman, 2, 3, 4, 5 months go by and I'm getting no response, I sure as heck want to be able to go to Superior Court, because 91A itself gives these right to know cases scheduling precedents in the courts. And my experience, which has been for, I want to say a few years now, but it's really 40-something years, is we do get prompt consideration in the courts. And as Justice DELKER said, in cases where the agency knew or should have known the record should be handed over, then attorney's fees and costs are awarded. So I don't have a particular criticism of the current system at all. I know there in Massachusetts, there's a supervisor of public records, sort of an intermediate step, but everybody who utilizes that step tells me that, yeah, we won before the supervisor of public records. The supervisor said, yeah, release the records. The city or town doesn't do it. And the supervisor has no teeth, no ability to enforce their decision. So you end up in the Superior Court anyway. I'm told Connecticut has a good ombudsman system, or at least a commission that hears these cases. And of course, you've got practical considerations. Is it going to be one person deluged with 5,000 cases right off the bat, and you're log jammed now? Is it going to be funded sufficiently? So I just don't know, but I at the risk of sounding like I'm brown nosing, if that's the proper term, the courts, I think they do a great job with right to know cases.
Can I make a plug for this bill?
Shoot.
Because it sounds like Greg's not as enthusiastic.
If you can keep it brief, and then we'll get
of this. And just so you know, this came out of a study committee 5 years ago to resolve the very issue that the questioner was kind of raising, is that absent some alternative process, you have to go to court. And it's easy for me as a privileged lawyer who has all of this training and experience to say kind of, just go to court. It's not that big of a deal. It's a really big deal, and it's a deterrent. Given the formality, the lack of access to resources, I think it hinders people from invoking their rights. And so I am very hopeful that this is a viable alternative process for people to get the relief that they need. And I'm happy to go into details offline because I know we're short on time.
Just really very, very briefly, I just want to share something that our questioner wrote in, saying that the city of Nashua, she says, has lost several right to know cases with Nashua residents, and the courts have still not fined the city for withholding that information. So that may speak to maybe some of the barriers of getting to a resolution through the current process. Just very briefly, Attorney Sullivan, Attorney Rice has been waiting here very patiently to weigh in.
I just want to say I joined Jill in that hope.
Casey, I don't really have anything to add on the bill. I can't. I don't think the city has taken a position, and therefore I can't take a position in this seminar. But I did want to just raise one, perhaps as a philosophical point, which is that you have a bunch of lawyers on this webinar, and many of us have been involved in right to know law litigation. Judge DELKER, sometimes decides cases brought before him based on the right to know law. We've mentioned the New Hampshire Supreme Court several times. There have been important changes and a lot of evolution over the last several years. But I don't want to leave the public with the impression that this is an adversarial process all the time. I mean, we're obviously talking about how the law has been changed through the filing of cases and legislative changes. But there are, thousands and thousands of right to know law requests that are made every day in the state of New Hampshire, which are responded to, quickly and in accordance with the law by public officials. So I just don't want people to leave this seminar with the impression that it's always adversarial, that we're always locking horns, that government doesn't want to, turn over information about what it's doing, because I think that the right to know law is a very important aspect of civic engagement. And I think civic engagement is something that serves all of us. I think it keeps our government strong. I think it keeps the government accountable to people. And I think that civic engagement is kind of the lifeblood, and that New Hampshire really has in addition to having this strong constitutional tradition, I think New Hampshire has a very strong tradition of voluntarism and civic engagement. For example, making our local elections run well. So I just wanted to throw that out there because, litigation is very, very important. The right to know law does have teeth in it in order to keep government accountable. But, probably, 9,999 times out of 10,000, the information is turned over without any conflict. But anyway, that's just my perspective.
No, I really appreciate that. We, just to put a brief plug in at NHPR, we are embarking on a series right now, just exploring civic engagement at the local level. And I think that's a really important connection that you drew between kind of the role of the public and the role of all of these themes that we're talking about tonight, and that kind of broader, thread of how we keep our democracy going. Justice DELKER, did you have something that you wanted to add there? Okay. Fair. We are winding down, so I think we may only be able to get to one more question. Just on a practical level, Attorney Bryce, if I could just stick with you. It was mentioned that, there's training, or you provide kind of like training. Whose job is it to get cities to actually go through that training? Is that something that you just undertake kind of proactively?
Well, I mean, I think that selfishly, it makes my job easier, right? If public officials are well trained, because then people know what the law is, and they're able to comply with the law, and they're able to appropriately ask our office if they have any questions. So there are all kinds of varieties of training. I mean, we provide an orientation, for example, to aldermen. We provide at least annual training to city department heads and employees on all kinds of things, but also including the right to know law, because that's a great, again, it's really good to be able to remind people of those principles. And also it's really good risk management, right? When we do get involved in litigation over the right to know law, I want to make sure that we have a very significant and important principle at issue. We may not agree, but we do understand that there are teeth in the right to know law, just as there are with any law. We don't want to create an environment where the city of Manchester is darkening the door of Judge DELKER's courtroom every time we have a disagreement. That's not how to run a city. There are free resources from the New Hampshire Municipal Association. Members of the public who are interested in the perspective of municipalities on legal issues, including the right to know law, can visit their website. The ACLU has a very good website that they put up all their court decisions. I assume the New England First Amendment folks do the same thing. So we want to basically create an environment where people feel comfortable interacting with the public in all kinds of ways, and that to the extent there's some esoteric legal questions, which sometimes they come up, that they're appropriately elevated to us, and again, we can have a dialogue with our clients and respond legally and respectfully to even the requests that we may not agree with.
I'm going to throw this question out here just very, very briefly, and I realize it's a loaded one. We do have a question asking for comment on public access to statements by public officials on social media. I'm curious to hear, anyone who wants to jump in, how social media factors into like these themes. Are you seeing that play a role or kind of influence how public bodies are thinking about what they can disclose or how they disclose information given, the kind of environment that we exist in right now?
Well, I just give a very, very brief answer. The question there is always, is everything that a public official says and does in furtherance of his or her, public position? And that's a really, really hard question to answer generally. So Greg said earlier that, cases depend upon their unique facts and circumstances. And I would say that the same thing applies when it comes to social media accounts, Twitter feeds, that sort of thing. I don't think that there's a silver bullet yet. If there is, we haven't found it.
Well, I want to be mindful of everyone's time tonight. Thank you all for joining us. Thank you in the audience for your great questions. Thank you to our panelists. I, for one, look forward to continuing to file right to know requests with the City of Manchester, to showing up in Justice DELKER's courtroom when appropriate, and following the lawsuits that Attorney BISSONNETTE and Sullivan are involved in. So thank you all for being with us and for sharing your expertise this evening.
I want to echo that by saying thank you all so much. This was really illuminating. And as we say good evening to everyone, I want to remind you that Sunshine Week isn't over. News outlets around the state and the nation are using their editorial and news pages to share stories and opinions on open government. This Wednesday, you can tune in to watch Attorney Greg Sullivan speak to the New England First Amendment Coalition, and you can access information and tools for using your First Amendment freedoms at our website, loebschool.org, and at the New England First Amendment Coalition website, NEFAC.org. So thank you so much, Judge DELKER, Attorneys Rice, BISSONNETTE, and Sullivan for joining us and for your long time and ongoing support of the Loeb School and Casey. We're so grateful for your moderation and your stewardship of our attendees' questions. I want to say good evening to everyone, and we hope to see you all back at the Loeb School very soon. Take care.